Internationalized domain names, or IDNs, provide Internet users with access to domain names using characters other than those in the standard English alphabet. But they have also created opportunities for cyber squatters to cause additional confusion for trademark owners and their consumers, as a case involving the Instagram trademark makes very clear. Hi, it's Doug Isenberg, and I'm here to talk about another recent decision under the UDRP, the Uniform Domain Name Dispute Resolution Policy. This decision involved a case filed by Instagram at WIPO, the World Intellectual Property Organization, and it involved this domain name, which at first glance looks a lot like the Instagram trademark. But upon closer examination, you can see that it differs from the Instagram trademark in two important ways. First, the disputed domain name in this case replaced the letter I at the beginning of the domain name with the letter L instead, which is visually very similar, especially in the lowercase form of those letters, which is how domain names usually appear in browser windows or email addresses. And the second difference, the one I'll focus on in this video, is that the disputed domain name replaced the letter A with an accented version of the letter A instead. Now, I've talked about the first issue here, replacing one English alphabet letter with another, in a previous video, when I discussed the domain name weisfarg0.com, which looks a lot like the trademark Wells Fargo, but replaced the two letter L's with the letter I and the letter O with the number 0. In that case, as I previously explained, the UDRP panel said that the slight visual differences between complainant's trademark and the at-issue domain name does nothing to distinguish the domain name from complainant's trademark. And the panel in that case went on to issue a decision ordering the domain name transferred to Wells Fargo. Now, in the Instagram case I'm discussing today, the panel reached a similar conclusion. But before I explain exactly what the panel wrote, let me provide just a little bit of background about internationalized domain names, or IDNs. Here's how ICANN, the Internet Corporation for Assigned Names and Numbers, which manages the domain name system, defined IDNs a number of years ago when it specifically promoted the use of IDNs as part of the expansion of the number of top-level domains. Internationalized domain names are domain names represented by characters other than the traditional ASCII characters, A through Z. Such domain names could contain letters or characters from non-Latin scripts, for example, Arabic or Chinese. Many efforts are ongoing in the Internet community to make domain names available in many languages other than those based on the Latin script. Now, the motivation behind the use of IDNs makes perfect sense. Native English speakers are certainly not the only people who use the Internet, so why should domain names be limited to English language characters? As an English speaker and as an American myself, I may not have a need to access other characters which don't even appear on my keyboard, but I can certainly appreciate that people in other countries use them every day. So why should they not be available in domain names too? The registration and use of IDNs, though, requires the use of what are called puny codes, essentially a technology for converting characters using the ASCII character set into letters used in some other languages. So in the Instagram case I'm talking about today, the disputed domain name consists of the characters xn-lnstagrm-fza.com, which are converted to create a domain name that looks like this, creating an accented letter A in place of a plain letter A. So the interesting question in this Instagram case and in other UDRP cases also involving similar cyber squatting tricks with internationalized domain names was whether the disputed domain name was, as the first element of every UDRP case requires, identical or confusingly similar to the relevant trademark. Now, the WIPO overview specifically refers to the use of non-Latin internationalized or accented characters as a type of typo squatting, which means that the disputed domain name is to be considered confusingly similar to a trademark. And although the panel in the Instagram case didn't cite the WIPO overview, it reached the same conclusion after Instagram argued that the domain name was almost indistinguishable from the Instagram mark. Here's what the decision said on this issue. Prior UDRP panels have found IDNs and their puny code translations to be equivalent. The domain name is confusingly similar to the Instagram mark, since it wholly incorporates the Instagram mark, other than replacing the I with an L and the second A with an accented A, which creates a minor distinction that would be easy for an internet user to overlook. Consequently, the requirement of paragraph 4A1 of the policy is satisfied. Now, interestingly, this isn't the first time that Instagram had to deal with this issue. In previous UDRP cases, other panels found that these domain names, each of which used internationalized characters, were also confusingly similar to the Instagram trademark. And of course, Instagram is just one of many trademark owners that have been targeted by cyber squatters using internationalized domain names. The bad news is that the bad guys can use IDNs to create even more opportunities for themselves to deceive internet users by abusing trademarks. But the good news is that the UDRP process has proven to be a very effective way for trademark owners to deal with this issue, as UDRP panels routinely order the transfer of domain names in similar cases. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.